Okay, so in this video we're going to talk about Marbury versus Madison and establishing judicial review as a power that the Supreme Court has. And so to understand this, first off we need to understand a little bit about why William Marbury, was suing James Madison, the Secretary of State. So William Marbury was appointed as a Justice of the Peace in the District of Columbia in Washington, D.C., or in that area. And he, along with many other judges, had been appointed by President John Adams right at the end of Adams' presidency. So the election was already over. We already knew Jefferson was about to be president. As a matter of fact, just a few days before Jefferson is president. And the Congress passes a new bill, a new law, that would basically create more judges. And they do that right before Jefferson comes into office so that Adams will be able to appoint them. And then they can approve these judges, and they would have a lot of Federalist judges in the judicial branch, and because they knew there was going to be a need, they knew they were growing and they needed more judges, and so if they didn't do it, then the next Congress would do it, and the next president would do it. Well, the next Congress was more Republican, and the president was a Republican. The new president was going to be Jefferson, and so they just said, hey, let's do this, and let's do it quick. Well, obviously that upset a lot of people, and it kind of fits with today's times. If you think about just recently, Supreme Court Justice Antonin Scalia passed away, and immediately people were talking about, well, what's going to happen? Who is President Obama going to use to replace him? And will the Senate confirm them, or will they not? And how's that all going to work? And that's with just about a year, not with a year to go for him to do that. So you can see that people are just kind of concerned about how that's going to happen, and he's got a year to get that done. Well, with these cases, it was just a few days, and so you can tell, people would be upset because, hey, they do this and they do it right at the last minute. That doesn't seem kind of right to some people. So William Marbury is selected by John Adams, and then it's sealed. He's assigned and sealed by the Secretary of State. But in those last few days, just a couple of days left before the new president comes in, there just wasn't enough time for all of these commissions to be delivered. Just in the hustle and bustle and the shuffle of moving and all these things, a few of these commissions are never delivered, and William Marbury's is one. And so then when President Jefferson comes into office and he selects picks Secretary or James Madison as his Secretary of State, he tells him, hey, don't deliver the commission. And so William Marbury sues Madison to force him to deliver the commission, because until he has the commission delivered, he's not actually going to be the Justice of the Peace. And so he sues for that, saying he's been rightfully appointed and it was all taken care of, it just wasn't delivered, and it's his job to make sure it's delivered. So that's kind of the issue at hand. So the Supreme Court of the United States, that's what SCOTUS means. So the Supreme Court of the United States has three questions that they have to answer. The questions are basically, is Marbury entitled to his appointment? So he was appointed. Is he entitled to that appointment? Is his lawsuit the correct way to get it? And the answer to both of those questions that were posed to the Supreme Court was yes. They said yes, he is entitled to this appointment. It was done legally. It followed the Constitution. Yes, he is entitled to the appointment. They should deliver the commission. And then the next question is the lawsuit the correct way to get it? Well, they said yes, he should be able to get. He should be able to basically sue for them to do what they're supposed to do. And so the answer to both of those questions is yes. But then question number 3, though, is the Supreme Court the place for Marbury to get the relief he requests? And the law, according to the Judiciary Act, says yes, that is. But the Constitution, in the Article 3 of the Constitution, says something else as to how what cases should be heard by the Supreme Court. And and it's different from what the Judiciary Act. So what John Marshall says, who's the Chief Justice of the Supreme Court, so what John Marshall says is that, hey, wait a second, the Judiciary Act is saying this case should be heard by the Supreme Court, when in fact the Constitution says it has to go through the appeals process. This kind of case should be going through the appeals process, so it's not following the Constitution. So the Judiciary Act itself is unconstitutional, and that's John Marshall's decision, and he is the Chief Justice, and it was voted. It wasn't just his decision, but the Supreme Court's decision, and he wrote the majority opinion there, and so what happens is Marbury does not become a judge because he says this is unconstitutional. This act that created him, created this position for him, the way it was written is unconstitutional. And this practice is called judicial review. Now, this idea that judges could declare laws unconstitutional is known as judicial review. We often say that Marbury versus Madison is the beginning of judicial review, because the Constitution doesn't specifically say that or anything really that close to it in the Constitution, but we do have state courts prior to this have already used this authority as well. So they have practiced judicial review, and as a matter of fact, in the Constitutional Convention, there was discussion about the federal judiciary having this right of judicial review. So even though it's not laid out specifically in the Constitution, the idea already exists that is part of the role of the judicial branch. And so what Marbury versus Madison does is really establish that. It sets the precedent for it. It says, okay, here we've done it now, and then future courts will then continue to follow that process. And so that is how Marbury versus Madison helps to establish the precedent of judicial review.